All right, good morning, everyone. We're here on motion hearings, case CR 2221-1624, State of Idaho versus Lori Noreen Vallow Daybell. We've got, by my count, 5 motions scheduled to be heard in her cases this morning. Mr. Archibald, Mr. Thomas representing the defendant, states here represented by Rob Wood, Tanya Rawlings, and Rachel Smith. Before we get started, I would note that there is a order governing courtroom conduct that's been issued in this case. I would appreciate everyone in attendance to make sure you comply with that order. In particular, parts 2, C, and D of the order, that any cell phones must be silenced or turned off at all times while in the courtroom, and any recording of either audio or video is prohibited under Part D of paragraph 2 of that courtroom governing, or the order governing the courtroom conduct. So please comply with that, anyone in the gallery. I'll go ahead and call the first motion we've got pending today then. In this case, there's been a motion that was filed on January 26th, motion to dismiss for lack of speedy trial. Court's reviewed the motion. The state filed a response and objection to the motion. On February 2nd, I've considered the objection as well. On behalf of the defense, who's going to be arguing the motion?
I will on this motion, Your Honor.
All right, thank you, Mr. Archibald. Who's arguing for the prosecution?
I will, Your Honor.
All right, Ms. Rawlings, thank you. Mr. Archibald, if you'd like to present argument, you may.
Thank you. The timeline of my client's arrest on other charges and on these charges has been set forth in my motion. For the jury trial that's set to begin April 3rd, 2023, my client will have been in jail 1,169 days without a trial. We acknowledge that she was not initially arrested on a murder charge or conspiracy to commit murder, but her bail was in an amount that suggested a multiple homicide case. For a $5 million bail or abandonment of children case suggests that the prosecution and the judge believed this was a murder case. Otherwise, it would not have been a $5 million bail. So I know for calculation purposes for speedy trial, we start from when she was arraigned in court, but I think that under the case law, the court can consider other factors, and that is another factor for the court to consider. And so here we are set for trial, and I believe in the state's response, they acknowledge, yeah, we're over. And they acknowledge that it's 44 days over, not months over, but any amount of time over is a violation of speedy trial. So the Constitution of the United States of America, the Constitution of the state of Idaho, the Idaho legislature, the Idaho Code has told us what speedy trial means. And speedy trial, under the statute, is 6 months from arraignment, unless the defendant on her own has postponed or caused the delay. So has Lori Vallow Daybell done anything to postpone her right to a speedy trial? The answer is no. This court has repeatedly assured her that it will respect her right to a speedy trial. And I want you to know, Judge, that she appreciates your comments on respecting her rights. She really appreciates that. And so here we are with a trial setting that the defense knows is outside the time of speedy trial. The state knows is outside the time of speedy trial. So what's the remedy? Well, Idaho legislature said the remedy is the indictment to be dismissed. Under Idaho Code 193501, the court must not think about it, not maybe sort of, kind of, but the court must order the prosecution or indictment to be dismissed if there is not good cause shown. And so what is the good cause? Well, what it's not is court congestion. Under the Idaho Supreme Court confirmed that court congestion is not good cause. In the State v. Clark case, at both the state and defense cite the leading Idaho Supreme Court case on this issue, what did the Idaho Supreme Court say? The last full paragraph of their opinion in State v. Clark, does it suggest that court congestion may substitute as good cause for a delay beyond the 6-month limit, even if the state cannot demonstrate adequate justification for the delay? We strongly disagree. Contrary to the magistrate court's belief in that case, this court, the Idaho Supreme Court, has never stated that criminal defendants do not have a speedy trial right because of court congestion. When examining the reasons for the delay, this court, the Idaho Supreme Court, has consistently maintained that overcrowded courts are to be a neutral factor, which nevertheless should be considered, since the ultimate responsibility for such circumstances must rest with the government rather than with the defendant. So that last quote, the speedy trial obligation is on the prosecution, not the judge, not the defendant, not the defense lawyers. The obligation to respect a speedy trial right is on the government, the prosecution. And so if the court says, well, we couldn't set the trial in February because of court congestion in Ada County, that is not on the court, that is not on Ada County, that is not on me, that is on the prosecution. Clearly under Idaho Supreme Court ruling. So that's the only remedy that the Idaho Supreme Court has stated is a dismissal. Now, could the state dismiss and refile? Sure, they can do that, unless the court decides that this is a violation of speedy trial. Then I think the dismissal would be with prejudice. But the prosecution always has the right to dismiss and refile a case without prejudice. But if this court determines that this is a violation, then the matter gets dismissed. Similarly, if the appellate court were to review this and say, after a jury trial, and say, yeah, speedy trial was violated, then that dismissal would be with prejudice, not without prejudice. So this is an issue that my client has made clear from her arraignment, that she's not waiving speedy trial. If it's anyone's fault, then according to the Idaho Supreme Court, that fault rests with the government, the prosecution. That's all I have.
All right, thank you for the argument. Mr. Archibald, Ms. Rawlings, state's response.
Thank you, Your Honor. May I remain seated?
You may.
The state will largely rely on the objection that has been filed with this court, but we do have a brief argument. The court has previously found good cause to continue the trial beyond the 6-month statutory guideline. And I think it's important to note that there is a distinction between the statutory right to a speedy trial and the constitutional right to speedy trial. And the defense has relied heavily on the 6-month statutory guideline But as noted in our response, there is a distinction between a violation of a statutory right versus a constitutional right. As the court has already made this determination that there was good cause to continue the trial beyond the 6-month statutory period, it is incumbent upon the defense to demonstrate that the delay in this case has crossed the threshold from ordinary to a presumptively prejudicial delay. As contained in Note 1 of Doggett versus United States, a delay is not presumptively prejudicial until it approaches 1 year. That is simply not the case here. There was a 44-day delay from the defense team that resulted in vacating the January trial setting. So although defense counsel argues that there is no delay attributable to the defense, we disagree. That delay that resulted in vacating the trial setting for January is attributable to the defendant, not to the state. Factoring in that delay results in a trial date of February 20th. The court's selection of April 3rd, 2023 is 43 days beyond that, nowhere close to approaching 1 year. And because the court has already provided an analysis under Barker v. Wingo in finding good cause, and because there has not been a showing of a presumptively prejudicial delay by the defense, the court should deny the defendant's motion to dismiss. Furthermore, I think it's important to note that Ms. Vallow Daybell has concurred with her co-defendant's request to transfer venue and the court's decision to hold trial in Ada County. And while we acknowledge that State v. Clark talks about court congestion as a neutral factor that ultimately is held to the courts or to the government, there is still the analysis provided under Clark regarding good cause and a delay that arises, I think, to the level of a legal excuse. And then the court's previous decision, the reasons the court found to delay the trial included preventing an improper severance of properly joined co-defendants, and those justifications still prevail, Your Honor. The brief delay in order to keep the trials joined and in consideration of the scheduling and logistics in holding the trial in Ada County, something that the defendant has agreed to and concurred with, we feel provides a reasonable and neutral basis for a short postponement that does not violate the defendant's speedy trial right. So for all of these reasons, the court should find there is no violation of the defendant's right to a speedy trial. The court has previously found good cause to extend it beyond the 6-month statutory guideline. We're not into a situation where we're violating the defendant's constitutional right to a speedy trial, and the court should deny the defendant's motion to dismiss.
All right, thank you, Mr. Rawlings. Mr. Archibald, do you have any rebuttal argument?
No, Your Honor.
All right, counsel, this is a motion the court has determined I'll take under advisement to issue a written ruling going through the analysis, the statute, and the constitutional rights, and we will get a written decision out on that. I don't think it will take much time to get that done. We should have that by next week. The next motion then that is scheduled to be heard today is a motion for individual voir dire. The motion is entitled Motion for Individual Voir Dire on Sensitive Subjects. It was filed on January 26th. In response, the state filed a pleading on February 2nd, which does not necessarily object to the motion, but maybe seeks some clarifications from the court in terms of the procedure that would be employed at trial for conducting voir dire of jurors. So at this time, we'll hear argument on that motion. Mr. Archibald, will you be arguing that?
I will, Your Honor.
All right, Mr. Thomas, if you'd like to present your argument in support of that motion, you may.
Thank you, Your Honor. We'll mostly rely on our brief for the individual voir dire. We believe that it's appropriate. I'm not going to belabor the subject based on our conversations when we were over in Boise on the 2nd. I think the court made it pretty clear that we were going to do smaller groups and that we would be able to accommodate individual voir dire when it became necessary. One thing that came out after I wrote the brief and submitted it, or the motion and submitted it, and prior to today, Mr. Archibald and I talked about the possibility of, I pointed out several subcategories or sensitive matters, those being punishment, publicity, mental health issues, domestic violence, drug use. We'd also like to put in religion, religious denominations, those kinds of things, because we believe that that's going to be a hot point or a hot button issue in the trial. Religion is going to come out a lot. A lot of these allegations revolve around religion, the LDS religion, and some of the we need. We submitted that in our proposal for jury questionnaires. I know the court has taken some argument on that and taken some opportunities to listen to both counsel or all three counsel from both the defense and the prosecution about that. But should it not be put into the jury questionnaires with regards to religion and those kinds of things, we'd ask the court to also consider allowing us to argue individually, ask these jurors individually about some of their religious beliefs and some of their. It's rather sensitive, and we believe that would be appropriate for individual voir dire as well. I have nothing further.
All right, thank you, Mr. Thomas. Who's responding for the state here?
Yes, Your Honor, thank you.
All right, Mr. Wood, you can offer the state's response at this time.
Thank you, Your Honor, and I'll also mostly just rest on our filing, our response. The state's position is that a good portion of the voir dire can and should be conducted in small panels, but certainly we do agree with the defense that certain sensitive issues can and should be dealt with and in an individual voir dire. I don't know that the state agrees that we'd put a broad blanket on every issue that should be covered in individual voir dire. There's some people who will be comfortable about speaking about certain issues in a panel and others who won't. And so I think we can take that up on a case-by-case basis. The issue of religion, I don't believe was really briefed. I will just inform the court that while the state understands that beliefs that may affect an individual's ability to sit in judgment are fair game in voir dire, the state will be objecting to any questions regarding people's denominations or congregations that they attend. We don't think that's relevant or that it's appropriate. I don't know if that's necessarily at issue today and can probably be discussed later. Just where it was brought up, I wanted to make that clear that the state does not think that's appropriate. In general, though, the state rests on its response. Overall, we think small panels are best, and then individual voir dire as necessary.
All right, thank you, Mr. Wood. Anything further on the topic of that motion, Mr. Thomas?
No, Your Honor, thank you.
All right, it's filed as a motion for individual voir dire on certain sensitive subjects. As a general proposition, the court does grant the motion. As counsel pointed out, we last week were in Ada County and while meeting with counsel there discussed some of the proposals for conducting voir dire in the case. The intention of the court is to, after questionnaires have been completed and reviewed, bring in those jurors who would qualify for voir dire. Would be brought in small groups, number yet to be determined, but likely groups of somewhere between 10 to 20 people at a time. The court will then permit individual voir dire, but not as a matter of right as to each panel member when topics are raised that the court believes may taint other jurors or cause discomfort with potential jurors who would not want to discuss their responses in front of the panel. We'll have arrangements for excusal of the remaining group to do individual voir dire. In terms of setting out or designating specific topics or subjects. I'm not going to do that at this point. I'll keep your suggestions under advisement. And then as we get into that voir dire, that may also implicate the suggestion or wishes of certain individual jurors who are more comfortable talking in front of others on certain topics, and some people are not. So we just have to make those determinations as we go. So on that basis, then the court will grant the motion, and that individual voir dire is going to be permitted. But the scope and manner of how it's going to be permitted will be further determined when we're actually going through the process at Ada County Courthouse for the voir dire of the panel. That'll be the ruling on that motion. And any questions on that, Mr. Thomas?
Thank you.
All right, Mr. Wood, any questions from the state?
No, thank you.
All right, that'll conclude that motion. Next motion is the motion to disclose penalty phase information. This is a motion brought by the defense, filed January 26th. The pleading is entitled Motion to Disclose Penalty Phase Information. Court's reviewed that motion. And I don't believe there's been any responsive pleading on that by the state.
I didn't receive one of those filed.
Okay.
Your Honor, I apologize. I will be arguing this, Rachel Smith, for the state. But there was a written one. I will run down to see if it somehow, it's an error on my part. Perhaps it didn't get filed. If not, we certainly will get that in by the end of the day. I'm looking at my draft, but I will certainly run down to see how that happened.
Okay. We can still put the matter up on argument then. So Mr. Thomas, you're the arguing motion, and Ms. Smith for the state. Mr. Thomas, you can present argument.
Thank you, Your Honor. This motion to disclose penalty phase information we believe is required under Gardner versus Florida, a United States Supreme Court case, came out in 1973. I understand that 1973 was a long time ago, but I think that that particular case was very pointed and very poignant on the fact that, number one, death is different. There are lots of issues there when we get to, if we were to get to the penalty phase, that the state needs to provide to the defense well in advance. Any arguments that they may be putting up, any witnesses that they may be putting on. I understand that our witness lists aren't necessarily required to be disclosed at this point until our pre-trial conference, I believe on February 24th. But it concerns the defense a little bit that in their jury questionnaire proposals, they put on some witnesses that we believe have no right to be put on there, or no business being put on there. One being Michael Wellner. We believe that if he's going to testify to anything, it's going to have to be in the penalty phase of the trial. And we believe that we are entitled to any information that, number one, may be mitigating pursuant to Brady as well as other cases, but also any other information that the state might put forward that we might be able to rebut. And so if the state's not willing to present that evidence, I know the state has been holding this case very close to the vest here, that they have not been willing to disclose any bill of particulars, have been very vocal about telling the court that they are not, we are not entitled to know their theories or those kinds of things, but I believe that we are entitled to know whatever it is that they have well in advance of trial, especially those things that are related to penalty phase. As I indicated in Gardner versus Florida, the court noted that death is different. The defendant has a fundamental due process right to all information that is going to be presented by the state. Other than that, we would just ask that the court require the state to disclose any information that they are planning to present at any penalty phase should it come to that. Thank you.
All right, Mr. Thomas, I guess one point of clarification. Has there been a specific discovery request submitted to the state on that issue and a response to that?
On the issue of disclosing penalty phase information or witnesses?
Yeah, as I read your motion, I understand the motion, what you're asking. It sort of appears in the form to me of kind of a motion to compel, but without a motion to compel being filed, where you're saying they need to turn over and disclose this information. I don't know if you've gone through a process to try to obtain that information through discovery and had insufficient or no response, or whether or not you see this as a different procedural posture.
I understand the court's view of that. There is a mandatory disclosure of discovery information. I believe that this is something that the state needs to do without a motion to compel, but if the court would so require that we do a motion to compel, we can do that. We have filed a motion for a bill of particulars, which the court denied. We have filed other motions where the state would be required to turn over evidence of their theories and those kinds of things. Those also have been denied. And so we're just presenting this to the court and to the prosecutor, indicating that we would like to have the rest of the information pursuant to Gardner versus Florida and other United States Supreme Court cases, Herman versus Georgia, Gregg versus Georgia. Those things are required. And so we were just bringing it up to the court's attention. But if the court is concerned that we need to file a motion to compel, we can certainly do that.
Okay, I appreciate your response, Mr. Thomas. Ms. Smith, what is the response from the state on this motion?
Your Honor, the state's response is that the state is well aware that putting aside the capital litigation cases cited by the defense, which are generally the proposition that the defendant is entitled to be on notice, Idaho's Criminal Rule 16 is the controlling authority for discovery in the trial, including penalty phase. Idaho statutes and Idaho criminal rules control this. And the state would argue that it's the same application for both penalty and the main case at hand, and we will follow Idaho criminal rule and will meet the discovery deadline of, and I believe it's February 27th when witness lists are due. However, the instructions in Idaho, criminal jury instructions for capital litigation outline what evidence can be offered. And the instruction the jury receives specifically allows them to consider any evidence offered at the guilt phase of the trial in their assessment of the penalty phase. So the state will supplement and make sure our written response is in the court file, but the defense in the court is on notice that we will rely on any evidence we use in the guilt phase for a penalty phase. 1. 2, that we also will intend to offer any evidence, as we've noticed up in our 404B motion, and then we will supplement before the discovery deadline a specific endorsement list or witness list for penalty phase. I'm not sure Idaho criminal rule requires us to specify, but to circumvent any potential appellate issues, we'll give them a witness list of who we intend to offer beyond guilt phase evidence for penalty phase. But part of our inability to give all of that statement today is we made a specific discovery request to the defense for penalty phase disclosure. We sent letters in December. We filed a motion to compel that will be argued today. In part, we haven't received any of the witnesses other than 2 experts that they intend to offer in mitigation. So we may have to just do a big blanket endorsement if we don't receive something before then from them. I was hoping that, I think Ms. Blake and Mr. Wood were hoping we could be a little more narrow in response to what they intend to offer, but we certainly will meet our discovery deadlines. So 1, we intend to offer anything in guilt phase and ask the jury to rely on anything they heard in guilt phase in line with the jury instructions. 2, We intend to offer anything that we've previously noticed up under 404B. 3, we will provide a specific witness list for penalty phase by the discovery deadline, and then we will supplement that notice should we receive late disclosure from the defense in that issue. As to Dr. Wellner or any particular witness, I think it's premature to have a conversation on that. Part of it is the state letting the defense know that we have an expert on the issue of hyper-religiosity versus using religion as an excuse or justification. And we have that witness available, and it can be a conversation with the court at the time we believe that door's been opened, or whether we believe that situation exists for penalty phase. And so, yes, the state understands and recognizes its obligation under Idaho Rule 16, and we will meet them. And I will provide this in writing if for somehow it's not in the court file. And I understand and respect counsel saying he didn't get it, and the court will make sure you have our written response.
Okay. Mr. Thomas, any further argument?
Yes, Your Honor. I would object to the state providing the court with any written response after right now. If it's not in the court file, then it should not be considered by the court. For them to say, oh yeah, well, we'll supplement our argument with a written response, denies the defendant an opportunity to rebut any of that information, to review any of that information. So I'd ask the court not to review or not to accept any argument if the court doesn't have it in its file. And certainly, since I don't have it in my file, I think we have an issue with that.
Your Honor, if I just may, to avoid any confusion, the state will provide a written response to the discovery request, not necessarily argument, in terms of, witness and that sort of thing. I wasn't suggesting we would do written argument.
All right. Well, this particular motion, for me, given the posture of the motion and what's been argued, I don't see it as a motion that's really ripe for a ruling at this time. I think the issue's been squarely put before the parties, which is a requirement of disclosure of this information in an adequate time frame to allow for a response or preparation for it for the trial's penalty phase if we get there. I see this again as kind of getting into the discovery issues of the case, which are governed by Criminal Rule 16.
Purdue University Global. Apply now at purdueglobal.edu.
Say moving forward then is a few things. To the extent this information is within the possession of parties and relevant to these issues raised, it does need to be disclosed as soon as possible since trial is coming up as quickly as it is. I understand we've got a deadline date in the court scheduling order for the pretrial conference, which is on February 27th. However, the court always looks at these things in fairness in terms of getting information so the parties can adequately have time to prepare for trial. It sounds like there's additional disclosures that are coming. We're not yet to the deadline in terms of the